Yeah, well, welcome to our breakfast series on the Corporate Transparency Act. So we're just going to run through some basics for compliance. Here is just an overview of what we're going to run through today. So we're going to start with an overview of the Act, then important filing dates, which I'm sure everyone's interested in, the reporting requirements, a few key terms, and then update and compliance required under the Act, reporting process, pretty easy. Just a recap of the key terms, legal implications for non-compliance, legal challenges, and potential next steps under the Act. So just an overview of the Act itself. It was enacted in 2021. It didn't become effective until this year. So businesses that meet certain criteria will have to file under this Act, basically a report to the Financial Crimes Enforcement Network. And it applies to many businesses, but there are also various exceptions under the Act. And then willful non-compliance with the Act can result in various penalties. So you companies that were created before January 1st of this year have to file by the end of this year. And then any companies created this year have to file within 90 days of their formation. And then going forward, any companies created after January 1st, 2025 have to file within 30 days.
So those are the deadlines. So what do you have to report? And this is a new federal law, so it's very broad and sweeping. It pulls in a lot of companies, pretty much most of the LLCs and corporations in the United States will have to make a report under this law. We're going to get into the details of what the exemptions are, but this is something that everybody should be aware of. And anybody who's involved in these companies will have to know about. Essentially, the main thing, so Morgan just laid out the dates that these reports are due. It's called the Beneficial Ownership Information Report. It's basically one form for each company, and you need to provide information about the company itself that's making the report, the beneficial owners of the company, which is a definition that we'll get into because there are a few different buckets of people that could be considered a beneficial owner. We'll get into that. It's basically owners and then people who are high-level executives or others with substantial control over a company. And then company applicants. So those are the folks who actually helped or did form the company. So if you were forming a company with Orr Reno as your attorneys, it would typically be your attorney and then maybe the paralegal in our office who also helped you form the company. So those are the three: the company itself, the beneficial owners, and the company applicants. The federal government is asking for your report information about all those people or entities. Yeah, so then on the right side here, there's a list of information. It's pretty basic information. You know, the name of the company, any trade names, DBA names, address, where the company was formed, which state, and EIN, your taxpayer number. For the individuals who are involved, who the government is asking for information about, it's your name, birthday, your residential address. You can't use a PO box here, and your driver's license or passport number, some ID, and then you actually have to upload a photo of that as well. So this information is all going to the federal government. It's not public, but it'll be in their possession now. The goal of this law laws to fight terrorism and money laundering, and other bad things. So they're just looking that this Corporate Transparency Act, they're looking for more information about these companies, potentially shell companies that people set up to do bad things. Okay, so I mentioned there's three types of information, like I mentioned, and for the company applicant, the people who help form the company, you don't have to provide that information if the company was formed before 2024. So existing companies, which is the vast majority of the companies subject to this act, you don't have to go back and figure out who you used as an attorney to form your company, you know, the 80s or 90s or 2000s, or even 2023 for that matter. Just need to provide information about the company and the beneficial owners. That's nice. So this slide has a flow chart that FinCEN, which is the agency charged with enforcing the statute, has put together to help you walk through whether you are a reporting company. A reporting company is the key term here for a company that has to provide this information. So it's basically corporations, LLCs, any other company that's formed by filing with the state, any US state, and then foreign entities are also covered if you, if the foreign entity registers to do business in the US state. So Tony's going to get into more information because there's nuance about what is a reporting company.
Good morning, everyone. I'm Tony. I'm a business and tax attorney here at Orr Reno. So we've been learning this new law just like a lot of other people. You probably may have heard about it from other sources, accountants and whatnot. But it's taken a little bit of time just to figure out how to get into compliance with this and who needs to get into compliance and who might be exempt from this new act. The act actually was passed a few years ago. It was passed very, very early in 2021 after the most recent presidential election. It was Donald Trump actually signed the bill. It was a bipartisan bill, but it was right before the change to Biden. So there was a few years of them making rules, setting up the registration website, and so now 2024, we're all getting the practical on the ground, experience with how to comply with this new requirement. So one of the key questions is, well, what are we talking about? Which companies have to comply? And essentially, we're really talking about corporations and LLCs. Those are things that you form with the state. They don't exist without going to the Secretary of State and making a filing with it. Subject to a number of exemptions. There are these esoteric questions relating to certain types of partnerships that might make a filing with the Secretary of State. I'm not going to get into any detail. We don't see those. 99.9% of our clients are corporations and LLCs. And it was pretty clear that unless an exemption applies, they have to do this filing. And by the deadlines, whether they're formed this year or were formed in the past. And in future years, new company formations starting in 2025 will only have 30 days to do it, with the assumption that people will now at that point know what they're doing with these filings. So basically we're talking about all corporations and LLCs, except an exception applies. There are a bunch of exceptions that if those exceptions apply to a certain type of company, they probably already know by now, such as insurance companies, banks, public utilities. All of these companies have lawyers and accountants that are telling them no, you don't have to file. So there's a few that we are seeing where an exception might apply and they may not know about it. The client might not know about it. And, that's not the publicly traded company, those know about it. It's the large businesses, quote unquote large businesses, it's tax exempt organizations and inactive businesses. So for a large business, for purposes of this law, which is very different from a lot of other, types of, you could be a small business corporation, S corporation, and be a large business for purposes of this act. So to be a large business, you need to have 20 employees on a full-time basis, and the full-time basis is basically 30 hours a week. And you've needed to file a tax return in the past year showing at least 5 million in gross receipts. So that wouldn't apply to any new formations because it wouldn't have had any revenue on a previous tax return. And we didn't put it on the slide, you need to have a US location. All of our clients here have that. There is this issue about, foreign companies technically would have to comply with this if they register with the Secretary of State. We don't have any clients, I've never seen it in my practice, if a foreign company is coming in, they're either not registering with Secretary of State or they're forming a US subsidiary. That's, that's the way it really works in the real world. They also, the 5 million gross receipts has to come from US sources. All right, that's not really that big an issue for New Hampshire companies. So, that's one possible exception. The 501c entities, that's another one that we're seeing. And so, typically those entities will know, if they are 501c entities or not, but sometimes it can be, a little bit more nuanced than being a 501c3. It can be other types of 501c entities. The inactive business, so that is kind of, people might latch on to say, oh, my business is inactive. There's a bunch of technicalities to meet there. So in order to be an inactive business, it will have to have been in existence before January 1st, 2020. It will have not engaged in not currently engaged in any active business, not owned by any foreigners, no ownership changes in the prior 12 months, not sent or received more than $1,000 in the prior 12 months, and it doesn't own any assets. So we have some clients that kind of consider themselves inactive because maybe, they've been in a wind up mode, but they might have a bank account still with $5,000, or they might have still, one particular asset or something that they're just holding on to, like an escrow account or something. So technically, or they were formed in 2021 and that was never used. All right, that won't technically meet the requirements for being an active company. Another important one that, there's like 23 possible exceptions, we couldn't list them all here. Another important one are entities wholly owned by an exempt entity. So for example, if you're a large business, you meet all those tests and you have a wholly owned subsidiary that owns a piece of real estate. So 100% owned by it, it will also be exempt. But if it was not owned 100% by the large business, but it had a 1% owned by a human being, not exempt. Unless it otherwise on its own meets an exception. So there's some nuance to this. There's a very good small entity compliance guide. Very simple, it's 45 pages long, so you know that every client is going to be reading this. But there's lots of checklists, there's lots of flow charts, it's really helpful. We pulled from the graphics right from it. And it does go through in more detail when we're able to. And this is what we look at, pretty much when we have a question, to say, oh, do you meet all of these 6 tests to be in an active entity? So if there's helpful resources, we're happy to, if you are interested, we're happy to email you copies of these. They're found, on the FinCEN website. But there is, we would love it to be that every answer is really easy, but sometimes there is more Morgan wants to. So I would say the biggest area where there's nuance we talk about, oh, we need to report all the beneficial owners of these entities. And generally, what they're talking about are owners who own at least 25%. And that can be pretty easy to identify for, for a typical local business, that's a 50-50 LLC, it's pretty easy to identify who those are. And when they're talking about beneficial owners, they're looking at, they want the human beings. So if it's indirect ownership through another entity, you kind of keep looking up to see who owns, the people who own things at the top. So that, that's an exercise that can be done. However, it's a lot more complicated than that, because although they, this whole act is based on, who are the beneficial owners of these entities, we want to stop the money laundering and stuff like that. But it's not just about owners, it's about people who exercise substantial control. And substantial control is a term of art that can be pretty vague. And I can look at it and I can say, wow, that could really cover a lot of people, when you get down to what they're saying substantial control is. So we'll go in a little bit more detail on that. But there are these other exceptions. So even if you say, oh yes, someone owns a certain amount, they exercise substantial control, there might still be an exception that applies to having to report that individual on one of these reports. So the exceptions are minors and, so children. And apparently, they don't say like someone, under 18. So it depends on whatever state. And I don't know, there might be some state where it's 16 or, but they don't use the age, of 18 or anything like that. So I guess if you have somebody who lives in a state and they're considered a minor in that state, then you don't have to report them, but you might, for example, have to report their parent if they're the ones with legal, control over, stock that might be owned by the minor. Another exception is for, nominees, custodians. So if there's, equity in an entity that's titled in someone's name, but they're not the true beneficial owner, then you are supposed to report the true beneficial owner. So for example, we have a client that's going through a divorce. The spouse we represent is listed as kind of the 90% owner of an LLC, and they have nothing to do with this business. They were merely put on the LLC to protect the other spouse from their creditors. And so, that's a question where we might say they're not really the beneficial owner of this thing. Might it be safer to report them anyway, report both spouses? It probably is safer that way, but I think we would have a good position to say, yeah, they're title owner of it, but they are not the true beneficial owner of it. As I mentioned, the test of beneficial ownership goes not only to owners of the equity, but also significant control. So oftentimes that might be an employee of the company who is making key decisions. So there is an exception for employees who exercise substantial control, but are not an owner at all, who can be fired or, replaced by the actual owners. But they can't, but if they're the president or the CEO, then the exception doesn't apply. So this could certainly apply to a number of people who are in key positions in a company, who aren't the president or the CEO, who don't own any part of it. They might have substantial control over it, but they would be accepted from having to be reported. The next exception are potential heirs. So if somebody is listed in a will, let's say, when someone dies, the owner of a company dies, pursuant to the will, it's supposed to go to their kid. But the person hasn't died yet. Okay, they don't have to be listed as an owner, even though they might in the future become an owner. That will could always be changed. And finally, if a mere interest of a creditor. So if someone loans money, they're owed money by the company, they don't have to be listed. However, if they had a loan instrument that could be converted to equity, then that would have to be listed. So as I mentioned. There is this substantial control, it's very vague. I still couldn't tell you that all of the nuance, but. What's clear is there are a few things that they're going after, so they're going after for substantial control, senior officers. And they've helpfully, listed some of those, which are president, CFO. General counsel, chief executive officer, and chief operating officer. So if you're one of those things. Unless the other exception I just talked about for employees apply, then you would need to be listed. And in addition, there's a catch-all of any other officer, regardless of official title, who performs a similar function to those officers. So again, kind of more vagueness, unfortunately, but I think for, there's the large operating company exception that applies. Not too many companies that are smaller than that have a bunch of these positions. So I don't know, but sometimes you might have a company where it's like everybody wants a title. So, unfortunately, they might then have to be reported. There's also this kind of weird thing, although when I thought about it, it makes sense. An individual who has the ability to appoint or remove one of those senior officers or a majority of the board has to be reported. And where we might see this on a practical basis is sometimes in an LLC, in the operating agreement. A certain member might have certain rights that they could appoint a replacement manager. So, that is something that could come up here. Typically, that person that would do that would own at least 25% already, but it is possible where, you could say, hey, this is, they're only getting 15%, but they're like a key, backer behind something and they want management rights. So it could happen on a practical level. I would say the most vague thing here, are important decision makers. So this is capturing people who have substantial influence over important decisions, including things like the nature, scope, and attributes of the business, like whatever that means. Like I couldn't tell you right now, what that, selection or termination of business lines or geographic focus, entry into or termination or fulfillment of significant contracts, like that could cover a lot of things. Finance such as sale, lease, mortgage, or other transfer of principal assets. I think that what it's going after is, let's say that you had someone that founded a business and they've kind of, given their or a significant amount of equity to like a lower generation, but they're still behind the scenes, like pulling the strings. And everyone knows, that grandma's still the one who's calling the shots. Like that would capture them. Are people actually reporting that right now? I'm highly doubtful that that is happening because it's just so vague. But if you were trying to go after, let's say, people who are using entities for money laundering purposes and other, they're very unlikely to have their name listed on the equity, but they are very likely to be the one calling the shots behind the curtain. So, I understand the purpose is to try to capture and suck those people into the law so that they could be prosecuted. So it's out there and it's hard to know exactly how to advise a client to say, well, there's no limit to how many people you might need to report. So every entity, they say, should have at least one person who is exercising substantial control. Even if the equity is owned, 10% each by 10 people, there should always be at least one person who's ultimately kind of exerting more influence than others. So they're expecting at least one human being listed for every entity. So another area is, okay, well, what are we talking about? Like sometimes we're, oh, they own 25%, they own 10%. And sometimes it's super clear, there's, a company only has common stock, We know all the percentages, we can do the math and say, oh yeah, that person has to report, that person has to report. That's pretty easy. It can be more nuanced with things like LLCs, where it isn't always the case to say, oh yes, you're you own 50%, it's a 50-50. Because sometimes these LLCs can have what we call distribution waterfalls, that where it's, it's like, okay, for voting, yeah, you own 50%, like that's clear. But for economics, at the end of the day, there's oftentimes a provision that says, okay, when we sell, here's how the money is gonna go. And the money isn't gonna go 50-50. The money is gonna go first to pay people back what they put in. And then after that, it's all done, then this person's getting 70 and this person's getting 30. Or maybe someone's getting 0 until everyone's recovered all their money. The people that put in the money have gotten a return that's been promised to them. But after that, the person that has started out with 0 suddenly goes to 35%. And we have clients that are very close to that fact pattern. So this is sucking in those people that even though right now they are entitled to 0, there's contractual provisions that say in the future they might own 35% or be entitled to 35% of the cash that comes out of it. They'll be sucked into being beneficial owners. Other things are, we don't really see them all that much, convertible instruments, so you have a debt that can be converted into equity, or options, things like warrants, so kind of more esoteric things that you might see in New York and Boston and stuff. All right, we talk about the company applicants.
So for any company formed after January 1st of 2024, they have to report their company applicant, which could be anyone that helped form the company, including the paralegal, the attorney, even the corporate founder, the original member of the LLC, just whoever filed the paperwork or helped file the paperwork to form the company. And with all of the reporting, you're required to update any filing for a change in the beneficial ownership or company structure, and also changes in information provided, such as addresses, passport numbers, things of that nature, names if people get married, etc. And so that can be quite burdensome. And the consequences for non-compliance are both civil and criminal penalties. But the act does provide that you have 90 days from the change of information to file the change of information without any penalty. But fines outside of that 90-day period can get up to $500 per day for delay in updating information.
I think it's 30 days.
30.
And let's go back to the company applicant for just a second. So for any entity that existed before this year, you don't need to report. We kind of mentioned that earlier. But just to give an example of who the company applicants are. A lot of times a client will come to us, we want to form an LLC. And so typically the form is asking for up to 2 company applicants. So a company applicant might be the attorney that's dealing with the client, and then the attorney is working with a paralegal here. The paralegal is entering data and putting it in the Secretary of State's website. So the attorney and the paralegal will be the company applicants. However, if we're not dealing with a New Hampshire formation, we're dealing with something like Delaware, we might use a service provider. There's different companies, like CT Corp, Cogency. So in that case, the company applicants will be the attorney and whoever's physically doing whatever they're doing in Delaware. So, the client wouldn't know that information. We would have to provide that information to the client if they are doing their own filing. So that's kind of what is meant by the company applicant. Now, a client can always form their own entities and they don't need to use a lawyer, in which case they would be the company applicant. internal people to the client.
Does the company have to update the company applicant's identification information?
No, it's historical, so once that's in there, then that never has to be updated. Good question.
And another thing is, I don't know if we're gonna get into FinCEN identifiers specifically, but, for us, you know, at Orr Reno, we're forming a lot of entities. Most of us have already gotten these identifiers, so we helped you form a company. We're not gonna be sending you our driver's license. Basically, you can upload your information once. Anybody can do this. If you're on a lot of entities and you're gonna be reporting your information as a beneficial owner on a number of entities, you can apply for what's called a FinCEN identifier, which isn't required, but you upload your information once and you get a unique, you know, string of characters that you can plug in. So we'll, you know, if we were working with you, we would provide that information to you. And so we're not trading too much personal information back and forth.
If anybody owns more, if anybody has to be listed on more than one of these reports, highly advisable to spend 10 minutes to get your own FinCEN identifier number.
Yeah, it's really easy.
It's FINSEN?
FINCEN.
CEN.
We can send you, if you give us your contact, I think we have a little flow chart about how to apply for one of those numbers. One of our paralegals has put that together.
Website's pretty user friendly. Yeah, it takes like 5-10 minutes.
Yeah, the key thing is you have to have a ready copy of either your driver's license or passport to upload to that website, but then you never have to give it to anybody else again, so.
But when that license expires, you need to upload a new one within 30 days?
Yeah, so if we were talking about this yesterday, if the number if anything changes, if your address changes, not your height, but if your license number changes, which I don't know in New Hampshire if you keep your number, I think you kind of keep your number, but if it stayed the same, you wouldn't have to. I think for passports, I think that they do change, you get new passports, so. But passports generally last longer, I think, than licenses do, so you might only have to update every 10 years. We have run into that, where we were gonna do a report for a client, and their license was expiring like at the end of the month. So it's like, well, we should just wait to get the new license, and then.
It might depend on the state too, if the
Right.
number changes.
Right, absolutely.
So the reporting process is all online, on the FinCEN website. And it's an e-filing, so it's either done through their web-based form, you click through it, or by downloading the form as a PDF and then uploading it. But there's no filing fee, it's just the information that must be provided.
I think there are third parties who are cropping up, people who are trying to make this easier for companies. I don't know if we have an opinion on if any of these tools will be good or useful, but I think, you know, towards the end of this year, existing companies will suddenly have to come into compliance if they're aware of this, you know, when they come to one of these breakfasts. I think it'll be interesting to see, maybe there will be good tools out there that like simplify some of this stuff. I heard of one that notifies you if your license is gonna expire, so it's like,
Well, it
keep
is.
you on top of that stuff.
It has, you know, we've started having, well, the compliance requirement came into effect January 1st. And, you know, any entities formed on that day, which there were probably none because it's a holiday, but there's been the 90-day period. So basically, you know, April 1st timeframe is when we really had to say, okay, the deadline is really approaching. And in that time frame, there have been businesses that have started where they will help with this process or, take care of the filing for some really competitive prices. So, I think that for a simple LLC, I've seen things like $49 to do it, which is definitely less expensive than we at Orr Reno could do it for. I've also seen, other law firms in the DC area, and it's, $500 to like even think about answering a question for a client on this. So it definitely is, people are offering these services. There's a wide range of prices. There's other ones one that does the 49 for one, it's like, oh, we'll do 49 for one, we'll do 99 for, up to 3 and maybe like 300 for unlimited. It's like, wow, like I can't say that we could beat that for a client. I don't know if they do a good job, but it seems like maybe the price will come down as tools are developed to help with this clients. But it's free for a client to do it themselves, and there's some nuance or the substantial control in some of these questions, but for a lot of businesses, it is pretty straightforward, and it should be, clients should be capable of handling it themselves, I think.
So yeah, we just wanted to have a slide recapping the key terms, because this requirement really comes down to a few key terms, basically reporting company, reports, beneficial owners, and company applicants on a BOI report, right? So CPA, we've been talking about the Corporate Transparency Act. FinCEN is the agency that is collecting this information, housing this information. It's part of the Department of Treasury. So you'll hear a lot about FinCEN. It's their website where they have FAQs and the small entity compliance guide, which we think is pretty useful. And it's long, like Tony said, but if you have a question, you can hone in on what you're concerned about and take a read. So yeah, the BOI reports, that's the beneficial ownership information report that you have to submit. And like I said, those are the sort of key terms in play here. So those are all the things you have to do. What if you don't? That's what this slide is about. I think we might have already touched on this, but fines for non-compliance, just not getting your report in on time, can be up to $500 per day for up to $10,000 total and up to 2 years of imprisonment. Yeah, so pretty powerful stick that the government has here. Senior officers can be responsible for their company's non-compliance. Can't put a company in prison, so somebody has to take the fall. And there's provisions in the law about willfully providing false information. I'd say on the spectrum, if you never heard about this law, which a lot of companies won't, and just didn't file a report, that, ignorance of the law is in a defense here. So that's not great. If you filed a report, but maybe you interpreted beneficial owner incorrectly and were under-inclusive, or maybe you did file a report and then your CEO's personal address changed, right? Both of those things would be non-compliance. They strike me as less culpable, and you'll probably not be facing the imprisonment penalty here. But I think definitely you want to be in the position of trying to comply and doing your best. I think that's the advice we can give here. There's also this safe harbor, which I don't find very useful, but if you submit a BOI report and then within 90 days after you realize that some information that you provided there was incorrect, you do have 90 days to file a corrective report without being out of compliance. I guess the potential use case here is maybe you're talking to a lawyer and trying to figure out who to report on behalf of your company, and the deadline's approaching. Just file it and then you can fix it within 90 days after that. So there's some use there if you really did run into that issue.
Alright, so now I'm going to just talk a little bit about legal challenges. So, the small business community is outraged at this burden. It is super annoying. I am sympathetic to that. I mean, I'm not in love with terrorists or, money launderers, so I understand the government's interest in trying to, shut that stuff down. It does seem that the companies that will be complying with this are probably not the money launderers and the terrorists. So those companies probably aren't going to be complying. Then there's these penalties that, they got Al Capone on a tax violation and maybe they could say, hey, you never filed a report, it's 2 years in prison for not doing that. There's sure to be a lot of non-compliance initially. People still don't know about it. It hasn't, I think, been well marketed by the government about this new requirement. They were supposed to have these outreach efforts and stuff. I don't personally see it happening, and so we'll see what happens in the future. But one thing that is happening is that court cases are being filed challenging the constitutionality of this law. So there's one that already, like, Speedy Gonzalez made it through the courts in one particular northern district of Alabama. And in that case, there was no jury, it was a judge, and he found for the plaintiff suing the government, saying that this law is unconstitutional, that it violates what is called the Commerce Clause. So generally, Congress has wide latitude to regulate interstate commerce. A lot of corporations and LLCs are engaged in interstate commerce. I mean, any company that's, paying a utility bill at all, usually it might be sending a check to another state. However, this judge found that, the constitutional threshold wasn't satisfied. And, so the plaintiffs in that case, which was the National Small Business I guess, association or something. So the government is currently prohibited from enforcing the law against that organization and its members. So since that has come out, there have been other challenges in other states, including, what I've read, one case in Maine. I'm surprised I haven't seen something in New Hampshire. It could have been filed and not, publicized or in media. But I would imagine there'll be challenges in every single district in the country, hoping to get, sympathetic judges to say, yeah, it's unconstitutional. Eventually, there'll be a circuit split, meaning a judge in one district will say, yeah, it's constitutional, and then there's this case in Alabama saying it's not constitutional, and eventually it will go up to the Supreme Court, and they will decide on, whether this law is valid or not. So the advice until that happens is, yeah, you're probably better off. I would say you're definitely better off complying with the law until it is clear that the law is not going to be enforced. But it will probably be in the news a lot that, yeah, there's more legal challenges and, different courts have struck it down while different courts are going to be upholding it. So, our advice to clients here in New Hampshire is it is currently enforceable against you. You need to be in compliance and these deadlines need to be met. For most of our clients, it is the December 31st deadline because they were formed before this year. So that was a lot of information in a short amount of time, but we're happy to, answer any questions you guys have.
Who enforces this? Like the IRS enforces taxes. Who is enforcing this? Like my $500 fee. Who's calling me? Who's sending me a letter saying, this is your penalty for not doing this?
It's FinCEN, Financial.
So that is who.
Enforcement Network. Yeah.
It's a Treasury agency.
Yeah.
Just like the IRS is, but that's not the IRS.
Gotcha. Okay.
And I don't know, have we seen any enforcement play out? Like.
Because that's
There couldn't really, no one's gonna be
Not much.
enforcement until April 1st, really, or
Yeah.
April 2nd probably, so.
Yeah, it's in the early days of seeing how it's actually gonna play out for, in innocent business owners
Yeah.
who could be non-compliant.
Any advice to companies in terms of, like, we have 17, 18 different corporations, some of which is still applied to, some of it is
Yeah.
not.
Right.
Should we start now and get
Oh.
this done, or do we wait in hopes that this is gonna get pursued?
Yeah, you know what, I might, I think I would certainly analyze the 18. If there's some with exceptions and you can say, hey, we don't need to worry about these ones, and then these ones we do have to worry about. Maybe I would hold off on the actual filing until, you know, the fall or something. I wouldn't wait till December 30th.
No.
But I don't, you know, I wouldn't say, oh, you need to rush out, you know, by, you know, May 15th and get all this done. Like, that doesn't seem what you need to do, but I would start the analysis process.
Yeah, I think beginning of Q4 probably.
Yeah, you know, people might
See
get
what's
really
going on.
busy with these filings, so.
In the Q3 we can.
But I would, you know, if you know, hey, we have these entities, and really we're talking about these individuals, and they're gonna have to be on multiple reports, you might just say, well, let's go and get the FinCEN ID numbers for them. Because then it's one less thing to have to, you know, worry about later.
Another question.
Sure.
So if you've got nothing to hide, when it comes down to, ooh, is this person reportable or not? What's the ramifications of more going off and reporting them? What's the consequences, I guess? If it's questionable, do you just go ahead and report them? I mean,
Yeah.
nobody wants their information shared, but what's the downside of?
Okay, well, so, you know, what happens with this information? There's this new government website, like, can anyone access it? Is it on a public? No, it's not a public website. So certain law enforcement agencies will have access. I was reading about it like last night, like it seems somewhat intricate. They have to enter a memorandum of understanding with FinCEN about the use of this information and how this other law enforcement agency is going to keep it secure and have systems in place. And of course, everything's hackable. Who knows exactly how secure it is or is going to be, but it isn't designed so that it's easy even for law enforcement to get this information. So I mean, if you have nothing to hide, I mean, the government already has your name through social security, they have your stuff through tax returns, I mean, they have a lot of information. This is kind of putting it in a different place and associating your name with certain entities. If you have nothing to hide, if it was me, I would just say, well, shoot, yeah, go ahead and list it. And then I don't have to worry about these potential penalties and stuff.
Just want to confirm that LLCs that are formed for real estate purposes are still required to report.
They,
Yeah.
absolutely, yeah. An LLC formed for no purpose that even just owns some stuff so that it's not inactive. Will have to,
Okay.
you know.
I think those will actually be entities that are hit quite hard because they're not parts of, they don't typically have employees or
Mhm,
or
right.
revenue but yeah, so.
They're good little shells.
Yeah,
Not that I'm doing that.
good shots.
From Netflix, you know, you learn a lot.
John, you must have more questions.
Thank you, very, very well done.
All right. Well, thank
Yes,
you
that was
all
it.
for coming.
Thank you.
Share the slides.
Yeah, we can share the slides and we could, you know, if you want the small entity compliance time, we're happy to send it to you. It's kind of a big file, in color, like, so it may be too big to email sometimes, but we'll do our best.
Thank you.
Yeah.
Very good.
Thank you.